75401, South City, Texas versus Billy Chemirmir. Before the jurors wanted to break for lunch, we received a note from the jurors, and it reads, Judge Jones, we remain deadlocked at 11-1. After additional deliberation, we perceive no change, and it is signed by the foreman of the jury. Is there any discussion between the lawyers of how we want to respond to this note?
We would request a full Allen charge be sent back.
All right, and
Judge, we would obviously object to the Allen charge being sent back, and even prior to the court making a decision on whether or not to send an Allen charge, we would either re-urge, resubmit, or just remove this court to grant a mistrial. This is the third note today from this jury, Judge. They have now been deliberating for approximately 7 hours regarding this. This is the second note consecutively stating that they are 11-1 deadlocked, and this one has put in language in there specifically stating that they do not see any. Can I see the note, Judge?
yes. Yeah.
Thank you. It states, we perceive no change. They are telling this court, and they have been telling this court, that they have exercised and they've done their due diligence in regards to deliberating this case. They're listening to the evidence that was presented in this court, listening to the argument from the state and the defense. We believe now, after this second note, after them being very clear in regards to where they are and explaining to the court situationally that they believe that they are not going to change. They're saying that the 11 is dug in and the 1 is dug in, which is their right, Judge. They've deliberated and they've made up their mind. So we're going to ask, Judge, that you take all that into consideration, and anything that will be sent back at this point, Judge, in response to this third note would be putting undue pressure. It would be coercive in nature. And at that point, Judge, if a verdict is, if you send back an Allen charge at this point and a verdict is rendered, then we feel like that verdict will be tainted because the one, whatever the one is, whichever side it goes towards, we feel like they would have been forced to violate their conscience in regards to reaching a verdict. And as I've stated before here, outside the presence as well, within the presence of the jury, is that they have completed their task. They've deliberated and they've reached their decision. And the decision is it's not a verdict. It's not unanimous one way or another. We're going to ask, and we believe it's only fair, and it's only right, and it's only proper, that you grant a mistrial at this particular point, Judge.
And Judge, I've got some stuff to add.
Yes.
Your Honor, I echo everything Mr. Warren just said, and what we also submit that any more Allen charges, any more directions from you to continue deliberating or to try and reach a verdict would violate his due process rights under the 5th and 14th Amendments of the U.S. Constitution, Article 1, Section 13 and 19 of the Texas Constitution, Code of Criminal Procedure, Article 104. We further believe that it would violate his, Mr. Chemirmir's right to a 6th and 7th Amendment, right to jury trial under the U.S. Constitution, Article 1, Section 10 and 15 of the Texas Constitution. And basically, anything more we believe would be coercive. The jury sent out 3 notes today. They've sent out 2 saying they're deadlocked. We believe the last one was coercive, and we double believe this one is coercive, and it's violating his. He's got a right to enjoy the rights of any other defendant charged in Texas. And those rights involve a full right to a jury trial, a right to be found guilty, right to be found not guilty, or sometimes for a mistrial. That is contemplated in the Code of Criminal Procedure. It's contemplated in federal courts and civil courts all across Texas and in criminal courts. And it's validated by the Texas Supreme Court and the Texas Court of Criminal Appeals, as well as the local Court of Appeals. So to keep hammering on you will continue to deliberate, we believe is abusive and coercive, and it's also a comment on the weight of the evidence, and then with all the state and U.S. constitutional issues or sites that I mentioned. Thank you, Judge.
Thank you. Thank you. So, for the record, and I will take this under advisement, but for the record, I want all parties to know that during the break, I did have the court reporter document for us and memorialize all the times that the jury has been deliberating. So, on November 15th, 2021, which was this past Monday, our AM session, the jury was in at 9:17 a.m. They broke at 12:06 p.m. for lunch. We then had evidence and testimony from 1:24 p.m. until 3:22 p.m. on Monday. On November 16th, 2021, which was that Tuesday, we had testimony from 9:23 a.m. until 11:49 p.m. and then they recessed at 11:50 p.m. on that day. On November 17th, which was Wednesday, we had evidence and testimony from 9:36 a.m. until 12 p.m. and then from 1:37 p.m. until 6:30 p.m. the jury had evidence and testimony. On Thursday, the jury heard evidence and testimony from 9:03 a.m. until 12:14 p.m. We then brought the jury back in at 2:32 p.m., at which time we had the jury charge read and we had closing arguments from both sides. Deliberations began with the jury at approximately 3:45 p.m. on Thursday afternoon yesterday. They then ended deliberations yesterday after having a 45-minute break at 5:30 p.m. They had a 45-minute break. They then deliberated until 7:51 p.m. last night, and we broke until this morning. And then, of course, we know what time they started this morning at 9:08, and they have been deliberating such time. So, with all of that evidence and information, I will go back, let me look at a few things, and I will come back and give you the determination of whether or not an Allen charge will be given.
And Judge, Mr. Warren and I want to add that we also believe and submit to the court that the certainty in the declarative state, if that's the right word, of those notes overrides any time frame, because the courts have used various time frames, and we're realizing is something valid, is something reasonable to declare a mistrial. Generally, it's construed against the state if it's granted too quickly. And so for the court to put undue emphasis on the length of time when these notes have been so adamant, and I'm referencing for the record, one using the word hopelessly deadlocked, and the third one using the phrase no movement, I believe, paraphrasing, that to apply a time thing to a time frame over the declarative and clearly stated pleas from the jury that they are unable to reach a verdict, we believe that that should override any time issues. And then I will also want to resubmit that most of the times when the court is second guessed on the time, that is when the court grants a mistrial in favor of the state when the state asks for it, over the strenuous objection of the defense. That's not the case here. We are asking for a mistrial. And so most of that law relates to when the court grants a mistrial over the objection of the defense.
All right, thank you so much.
And Judge, I'm sorry, just so the record is clear, are you reserving ruling on our motion
I
regarding?
haven't said yes.
Okay.
So I am going to take all of what was said by the defense under advisement.
Okay.
And I will come back and I will let you know that the choices are whether, the choices are right now. Of course, the defense has asked for a motion for mistrial, and the state has asked at this time that an Allen charge be given. So I will take everything under advisement. I will go back and I will come back and give you a decision of which way we're going to go.
Thank you.
All right? Thank you. You're off the record.